Okay, so I'm going to go ahead and call the matter of Jill Henricksen, now known as Rogers, versus Ryan Henricksen. The case number is 174901023. Council appearances, please.
Michael Ferguson on a limited scope for petitioner.
Eric
Okay.
Johnson on behalf of the respondent.
All right, what's the status? Does this require argument?
It appears so.
All right, so this is began as Ms. Hendrickson's, Ms. Rogers' motion for an order to show cause. And Mr. Ferguson, you can go ahead and present argument.
So the issue in this case is just payment for daycare. When the parties got divorced, there was no portion of the decree that stated each party would pay half of the cost for daycare because Ms. Rogers was a stay-at-home mom. But then she got a job and they needed daycare. They communicated, talked about which daycare would be best. And then the respondent at some point realized the decree did not specifically state he should have to pay half for daycare. And it is my understanding that it is his position, because it's not in the decree, he should not have to pay any of the costs for daycare. Well, the petitioner just wants him to pay half of what has been spent so far on the daycare for their children.
All right. Is there any legal argument as to why the court should impose that obligation if it's silent in the decree?
I mean, it's the default language, just, that's kind of where the rubber meets the road, obviously. But you go through the texts, and Exhibit F in particular that was filed with the motion is just his acknowledgement that he was agreeing on which daycare to use. And then at the end, in his response, everything is, oh, I know I was talking about agreeing to daycare, but I assumed she would cover all the costs. And I don't think that's the case. I think it was just he realized he had a loophole, and he believes he has a loophole that lets him get away with not paying for his kids here.
Okay. Okay. All right. Mr. Johnson.
If this were a trial, I would move to dismiss on the grounds that she has failed to state a claim. It's obvious. You can't be held in contempt when there's no court order.
That it?
Yes.
Okay. Any rebuttal?
I believe, there's certainly some merit to the talk of contempt in terms of the court order, but at the very least, there should be some discussion going forward on the daycare costs. If not, they have not been spent so far. I think that's certainly something the court should consider.
All right.
Your Honor, can I respond to that, since that's something other than what was in the original argument?
Okay.
Okay. Well, this is a motion for order to show cause. The only thing you can do on a motion for order to show cause is hold someone in contempt. The court, any court, can only hold someone in contempt. So in order to hold Mr. Henricksen in contempt, there has to be a court order. There is no court order. He cannot, as a matter of fact and a matter of law, be held in contempt of court. Asking for any other kind of relief is improper on a motion for order to show cause. Even raising an oral motion at the motion for order on order to show cause would be improper. We object.
So your argument then really is a 101 type argument. Let me go ahead and take a look here.
My argument, or Ms. Rogers?
Yeah, Mr. Johnson, on the judgment part of this. Is that right?
I don't understand what the question is.
Well, you have two parts, really, I think. One is you're saying there's no order, so you can't enter a judgment. And two is that you can't ask for a judgment on an order to show cause. Is that what I'm hearing you say?
No, what I'm saying is the only thing that can happen, the only basis for a motion for order to show cause is to hold someone in contempt for willfully violating a court order that they know exists and that is valid. There is no court order ordering Mr. Henricksen to pay daycare.
I agree with that. It's silent.
Right.
Okay.
And no one can come into court on a motion for order to show cause seeking new orders or judgments. That's established clearly in case law. In order to seek something like that, you have to file a petition to modify.
Right. I was not meaning that it should happen today, Mr. Johnson. I apologize if that's.
Oh, right. I'm not upset with Mr. Ferguson at all. But I do take Mr. Ferguson and his client to task on the subject of saying, well, even if we don't have a motion for order to show cause basis, this is something we're asking the court to consider later on. That may be an expression of a desire, but it's certainly nothing the court can do anything about because it can't be properly before the court by under these circumstances or by an oral motion.
Well, okay. Anything you wanted to say, Mr. Ferguson?
No, Your Honor.
All right. Well, I have some concerns. I agree with Mr. Johnson that where there's no language in the decree about payment of child care, the court can't find the father in contempt for not reimbursing the child care. Contempt requires an order, that there is the existence of an order, that the alleged contemnor knows about the order, has the ability to comply, and fails to comply. When there's no order, there's nothing for the court to do in terms of a finding of contempt. But I feel differently about the judgment aspect of this, and I'll just indicate this is assigned to Judge Chan. This may be a legal question, but in my view, the child care provision is part and parcel of child support. The child care provisions are in the Utah Child Support Act. The decree is silent, and in my view, the responsibility still exists to pay for the child care. All right, he may not be able to be held in contempt, but I think he's still responsible for 50% of the child care costs that are incurred, and as long as the provisions of 78B12214 are being followed. And I do find it credible that the petitioner, as she indicated in her paperwork, had been providing the respondent with communicating with him, telling him how much it costs, providing verification at various times. I view the father's position here as an attempt to avoid responsibility. The child care provisions, as I indicated, are found in the Utah Child Support Act. And when we go there and we look at the language of the statute, this is, again, 78B12214. It talks about, in the absence of a court order to the contrary, a parent who incurs child care expenses shall provide written verification of the cost and the identity of the child care provider. I've already indicated my feelings about that. And then it also indicates in subsection B2, in the absence of a court order to the contrary, parent shall notify the other parent of any change in child care provider, et cetera. So it talks about any actual expense that's incurred, the parent shall begin paying his share on a monthly basis immediately upon that presentation.
It says nothing of the kind.
And my view is this, is that the way the statute is, that if there was a provision in the decree that said specifically that he was not responsible, and that the mother would be paying 100% of the daycare costs, that then that would be a legitimate defense. But I don't find it legitimate to say that because there's silence, he doesn't have to pay, because we have a statute that requires payment, and it's part of the Child Support Act. So my recommendation is going to be that the judgment enter for the 550440. I'm not awarding fees. That I think, and there's no contempt, but from this point forward, I think the parties are on notice, and they need to comply. She needs to comply with the verification requirements of 78B12214, and he needs to pay as it applies pursuant to the same statute. That'll be my recommendation for today. And Mr. Ferguson, we can have Mr. Soroka prepare the order, or we can have you do it, Mr. Johnson, if you want to. Otherwise, I mean, you didn't prevail. I don't know if you want on that issue, so I don't know if you want to provide the order.
Can you hear me?
To draft the order. I can hear you.
Okay. Your Honor,
I'm not going to argue about it with you. I made a recommendation. You know what your rights are under 108.
hey, but I will note for the record that the court has misconstrued 78B12214.
That's an argument to be made to Judge Chan, not to me.
So let me make sure I understand the court's order. The court is saying that because there's a statute that says the support order shall require that each parent shall share equally. The court is then finding that an independent obligation exists, a separate and apart from any order, which we both concede does not exist.
Every
And that-
parent has the duty to support their child under the Child Support Act, and this is part of the Child Support Act.
But the only way that
my
can be enforced
recommendation.
is if there's a court order. Subsection 1 of 78B 12-214.
Like I said, that's an argument to make to Judge Chan if you choose to go there. I've made my decision for today.
Thank you, Your Honor.
Mr.
I'll be
Soroka,
happy
will
to
you prepare
prepare-
the paper?
Yeah, I'd be
What's
happy.
that? Mr. Johnson,
You ask if I would prepare the order, I'd be happy to do so.
thank you.
I will be filing an objection to the recommendation.
Very good. All right, parties are excused in this matter. Mr. Ferguson, do you want the order directed to you?
Sure.
All right. So if you'll send the proposed order to Mr. Ferguson, he can
Okay.
review that.
Is Mr. Johnson or Mr. Soroka doing it?
Mr. Johnson.
Okay.
All right. Thank
I'll
you,
send
folks.
you my email, Mr. Johnson.
Yes, I have one other question, Your Honor. You mentioned that the statute says that one is obligated to provide payment of child support upon being presented with a claim, but can we agree that that is not what the statute
I'm
says?
not going any further with this, Mr. Johnson.
Oh, okay, well, I'm just simply, for the sake of the record, I mean,
I'm done
not
with
sure.
this.
Okay, well, I'm going to state then that the court has stated that.
You can state whatever you want, sir.
Right, that 78B-12-214 says that Mr. Henricksen in this position has.
That's
an
your
obligation-
argument on a 108 objection.
No, I'm saying that's what I'm asking the court to state if that's what it said. I heard the
The
court
statute
say-
speaks for itself.
Fair enough.
Thank you.
Okay, Your Honor, I will call Ms. Rogers just to conclude, and then I'll go into the breakout room.
All right. Thank
The other
you.
case.
Do you want me to put you back in the breakout room, Mr. Ferguson?
I can do it myself when I'm ready.
All right. Thank you. All right. So it looks like we're still waiting for Ms. Giacovelli in the Alexander case. And I'll be in brief recess.